Welcome everybody to today's iteration of Law After Lunch. I am pleased to introduce that we have with us today Dr. Lina Escobar. Lina is an assistant international law professor at IAFIT University in Medellin, Colombia. Her research interests involve international economic law, natural resources, and sustainability. Aside from being a professor at IAFIT, she also advises mining companies that invest in the country, particularly in territories that are held by Afro-Colombian and indigenous communities. Lina is a law graduate of the University of Trento in Italy. She also holds an LLM in international law from the University of Heidelberg and her PhD in law from our home university, Martin Luther University, under the supervision of Professor Dr. Kristen Titia. Today she'll be speaking with us about competing international regimes and global interest, specifically focusing on energy transition, investment, and indigenous rights. So we're very pleased to have you and look forward to your presentation.
Thank you, Christina. And vielen Dank. Ich will besonders Herr Titia für diese Einladung danken. Leider schaffe ich es nicht, auf Deutsch diese Präsentation zu halten, also jetzt wieder auf Englisch. When I was thinking about what I could speak with you guys about, and I must say I'm really humbled and happy to be here this side, and not as a fellow student, but as presenting some insights from from my research interests in Colombia. I actually thought that putting together some considerations that I'm still putting this puzzle together, but some considerations on facts that have developed over the past year and some reflections on how those facts relate to international law regimes seemed appropriate in a context where we have, global conversations on climate change, on how we have to transition to renewable energies, and how this is impacting, for good or for bad, communities in the so-called global south, and within the global south, and how this global south is fragmented in the sense that within the territorial state units of the global south, obviously we have indigenous communities with a certain, and in the Colombian case, a developed degree of internal self-determination. And so how this comes together under current international law seemed interesting to me, and it's more of a research proposal actually that I'm thinking of putting together. I have some ideas, and I feel really privileged to be able to be presenting this and discussing this with you guys. So first of all, the notion of global interests. I put that in the title, and then I realized that the correct term would be the community interests, of which we've all read about, and I wonder why the term global came to me, and I pondered whether this was a mistake or whether I should change it to community interests. I decided to keep global interests in the presentation, but the underlying meaning of the expression global interests in this context is community interests. And by community interests, what we refer to in international law is this idea that there would be interests that transcend the territorial state, that are interests of the global community as a whole, and this global community as a whole would include not only territorial sovereigns, but also several stakeholders or actors or subjects. We'll see how these categories of international law seem quite unfit for purpose in the current circumstances. And in the case that I'd want to discuss with you guys, the global interest or community interest that is spurring the discussion is climate change. It's climate change as it is the catalyst of investments all over the world. In Colombia, it's the same thing happens. Investments in renewable energies, which at turn imply access to territories. It implies access to critical or strategic minerals, and hence mineral developments and investments. And it seemed interesting that if you look at the SDGs and you map them out and you see how they all relate to each other under this integrated framework, what we do have in common in this integrated framework is that SDGs, or the implementation of SDGs, are called upon not only by states, but also by what they refer to as stakeholders in the 2030 agenda, and so there seems to be the current insinuation that these objectives, well, are objectives that are incumbent not only upon the territorial state, they would be incumbent also upon, stakeholders more broadly. One could wonder, and this is perhaps one of the questions that we can draw from this reflection, are they incumbent also upon Indigenous communities? And how are they incumbent upon these communities, or how are they incumbent upon a state in the global south? So the beginning of the story starts with a new government. Colombia has, well, it's almost 2 years now since the election of the current president. And one of the first measures, or it was a campaign issue, and one of the first measures that the government took was to really emphasize the commitment, and emphasize this commitment on an international stage, the commitment of the country to energy transition. So to develop renewables, to bring investors to the country to develop these renewables. And in that sense, one of the first public events of the former Minister of Mines was to present to investors the possibility of investing in Colombia, particularly in a region of Colombia that is in northern Colombia, that is a desertic region where winds blow very fast, and so the potential for wind energy is huge, which also happens to be a region where the biggest indigenous community of the country lives. It's the Wayu tribe, and it's more than 250,000. Sorry, more than 250,000 people. So on the one hand, we have this investment, this call for investment, so by the government, and as things have unfolded, and as investments have come to the region, they've also faced challenges. And just to sum it up as an example, and we won't delve into a lot of details, but following its investment in the region, Colombia decided to suspend the construction of its wind park in this particular region in Guajira, which is this desertic region I was telling you about that is in northern Colombia. And so it decides to suspend, and the whole project is now halted. The investment is stalled. The wind park isn't entirely developed. And the reasons behind this are complex, but a big deal of this has to do with the issue of community relations, and how community relations are fractured by the presence of these investors, how the indigenous communities among themselves and their government systems interact with the investors. And so obviously this raises a lot of questions in international right, because Colombia is part of several regimes, and these regimes are speaking to different constituencies, if you like. On the one hand, obviously you have the state, the territorial state, which, as we will see, is perhaps an inadequate reference or way of understanding how to interact with these different stakeholders that participate in this global interest, which is the climate commitments. And so you have the state with its investment treaty obligations on the one hand, so its obligations towards the investor. In the case of ENED particularly, this wasn't or really isn't an issue, but ENED is just an example, right, of an investment that isn't working out or hasn't worked out. And so what does this mean under the international treaty regime? On the other hand, you have that same state that, as we know, these polyphacetic creatures that are states, it's not only catering to the foreign investor, it's also catering, as we know, to multiple other interests. One interest has to do with its indigenous communities, and these indigenous communities, in the case of Colombia, a country that has ratified Convention 169 of the International Labour Organization, have a right to be consulted, or from the perspective of the state has an obligation to consult these communities, and so it's a state obligation, as we will mention in our delve into with more detail in a little while. On the other hand, you have the investor, and so the investor itself is embedded within the network of what is the investment treaty regime, if applicable. It's already mentioned, and it doesn't really apply in this case, but it's just an example. But you also have all of the soft law, business and human frameworks within which the investor operates, and that generate this transnational, way of doing business, and also these transnational standards of how the company, the corporation relates to Indigenous communities. And then, of course, we have the Indigenous communities, which are to be understood under a traditional perspective of statehood as part and parcel of the state. They have a right to be consulted, but they also have a right to internal self-determination, and the way that this internal self-determination is developing also seems interesting to me, particularly in the context of how it's developing in Colombia, because it's deepening, right? And so it's deepening, and it raises all kinds of questions of how then the rights of these communities and the way that they basically determine the access to their territories can relate to investor responsibility or to state obligations. And so the underlying thread of these different regimes and how they interact, obviously in this case, for the reasons that I've already pointed out, are the energy transition, climate change, and the tension that comes with this, because it's a tension that has to do with access to territories. And obviously access to territories doesn't lie exclusively within the purview of the state, which is sort of the big conundrum. The state has a set of obligations, but in the case of the multicultural state, Colombian state, for example, access to territory is conditional upon access and conversations and consultation and consent. There's a lot of question marks on what the term should be with the Indigenous communities. And so I wanted to go through these three different actors, subjects of international law, and see how they all ground sort of their position within the global interest or the community interest of climate change. And from that, they derive, or they work with different international frameworks. And that's where sort of it's difficult to put the pieces of the puzzle together, because the frameworks, obviously the traditional frameworks of international law, aren't exactly built for, on the one hand, constituencies that are different from the state territorial one, and on the other hand, these global problems. And so, when government launches its energy transition effort, it launches it and relaunches it recently at COP28, also calling for investment opportunities again in wind and solar. And this happens right after, so this was at the end of 2023, the decision by Anna to stop the construction of its solar farm was in June 2023. Which is interesting in terms of how government sees the way it can manage access to these territories and agreements with the communities. And so it's the government, and the decisions that the government takes from the policy point of view are firmly grounded in this community interest. It's a policy of the government Colombia is firmly committed to contributing towards energy transition and to prevent climate change. At the same time, we have an issue with access to natural resources from the territorial, on behalf of the territorial state. So the territorial state, in the Colombian context, both the Constitution and the Mining Code, and I'll mention in a moment why I'm referring to the Mining Code, because there's also an issue of what we consider to be natural resources in the context of renewables. The state owns the subsoil, and so the issue of the inhabitants on the surface of the territory, we'd say it's irrelevant to the ownership of the subsoil. And the subsoil is exclusive ownership of the state. And so this in terms of access to minerals, as we will see, raw critical minerals for energy transition, copper, so on. It raises the question as well of what we understand by natural resources, non-renewable natural resources. Is wind a non-renewable natural resource within the, in the conversations, and this is, you can Google this online, you hear the Wayuu indigenous leaders that have run into shortcomings in the negotiation of the access to their territories. They characterize the wind as being theirs, a resource of their territory. These territories of which, or the resources within the territory of which the state is the exclusive ownership in international law are governed by a principle of permanent sovereignty. At the same time, the challenge of access to resources in a context of interdependency of these minerals for climate change has spurred a series of initiatives, software initiatives, MOUs, understandings that are signed between countries like Colombia and industrialized economies, which are essentially cooperation agreements. It's underscored in these agreements that the access to resources is, or the cooperation that is framed in these agreements is not binding. And it seems to be the way that increasingly capital exporting states, industrialized states in need of these raw materials are working around the issue of access. If the state is the sole owner, if it has natural or permanent sovereignty over these resources, how are we to guarantee ourselves a position of preference to access these resources? And so this soft law sort of network is starting to build up. In the case of Colombia, there are several of such MOUs that have been signed with France, with Italy, with Korea, that are nothing but an MOU, but establish these conditions for cooperation to develop renewable energies. And within these MOUs, it obviously non-binding, but the actors and the signatories of the MOU are states. So, populations within the territories where the resources are to be accessed under these cooperation agreements aren't part of these documents, which aren't a formal source of international law. So, that also raises questions: could they be? So this raises reflections in terms of in the Colombian context. Some of these considerations are in a way also extendable to other regions of Latin America, and that is that yes, it's a territorial state. Yes, the territorial state, within the law owns the subsoil and it has permanent sovereignty over the subsoil. Hence, the state is also the actor that is conceding access to these resources through the concessions. But if you look at the map, you also see that everything that's in orange are also indigenous territories, indigenous collective territories. And so there is an overlap and hence an intersection of regimes in these territories, because on the one hand you have a surface right that belongs to the communities, to the indigenous communities, a surface right that has granted them, in the case of Colombia, very deep internal self-determination. But obviously the subsoil still remains within the purview of the state. And this kind of tension, this kind of overlap, which is a tension, is exacerbated by the other overlap, which is the foreign investor, or the national investor for that matter. But the foreign investor obviously has a regime complex of international law that generates another overlap in this picture. And so the way that the Colombian state purportedly aims to solve this conundrum is through the duty to consult. So the duty to consult would be the way, the key that unlocks that tension whenever there is a measure, be it a legislative or an administrative measure that can affect directly these communities, the state has a duty to consult. The duty to consult is enshrined in International Labour Organization Convention 169. It's a state duty, okay? It's governments that carry this out. It's nothing to do with the companies. It's a state obligation, and it's a fundamental right of the indigenous peoples. In Colombia, the issue of whether there is a duty to obtain FPIC, so the free, prior and informed consent, is a discussion. The Declaration of Indigenous Rights was, Colombia's decision in that declaration was an abstention, and precisely the reason for that abstention had to do with questioning access to territory for military operations, and the issue of whether the consent is actually a veto for these projects. And in the case of the duty to consult, it's not understood as a veto, it's understood as a meaningful participation with a view to generate consensus, but the community under ILO C-169 does not have the ability to veto a project. So that's the framework of the state with regard to territory and access to territory, and we see already that it has a challenge, this multicultural state, because on the one hand it is the head, that pops up on the international level and is calling for investment in the territory. It's also the head that pops up on the international level and is saying, okay, multicultural constitutionalism implies a duty to consult, it implies internal self-determination, but on the other hand, internally it faces real challenges in terms of organization of what these territorial, autonomic entities mean, how they manage themselves, how they represent themselves. If we look at the investor also, places its claims and places its position within the issue of a global interest. Just like the state is calling for investors to incentivize the investment for an energy transition. So do companies when they reply to that call also say, we have to move forward to renewable energies. And it's interesting to see that when ANN started investing, they said, explicitly, we have to make the step. It's a necessity under the current framework, of the world's pressing need for global change. And at the same time, when they decide to stop the investment, they regret that they have to come to that point, saying that this decision is difficult, not only as a company, but also as citizens that are concerned with energy transition. So again, the narrative, of this thread of the common or the global interest is also where the corporation is starting, the point of the corporation. I already mentioned that the corporation has different networks of international treaties that could come to its aid. Investment regime is obviously one of these. The question here for the corporation is, with regard to community engagement, does the issue of engaging with indigenous communities imply some other kind of international responsibility, or perhaps imply some other kind of even obligation for them in the context of these long-term interactions with territorial entities that are autonomous within the Colombian constitutional territorial organization. And so there are interesting questions of how, yes, a prior consultation is a duty of the state, it's a state obligation, but how do companies then play into that duty to consult? And how do companies relate without or beyond the state with these communities that are settled on the territory where they will be operating for decades? In that regard, there is a trend under standards to call for, and this was also an explicit call, for example, of the Colombian president, to call for these mutual benefit agreements or impact and benefit agreements, whereby basically the community and the investor engage in a private agreement where they share benefits, and the question is, how would they share risks? And so that approach makes us, looks at the relationship between the investor and the community beyond the obligation of the state to consult. The obligation of the state to consult is perhaps a step, it's a building block on the way, it's a fundamental right under constitutional jurisprudence, but it does not salvage, it does not prevent and should not prevent the company from engaging meaningfully with the community, and how, that's another question, right? And so whether this is under international law, is under international purview or not, it seems to be sort of a blind spot, that isn't exactly charted for or catered for under current traditional sources of international law, although plenty could be said of soft law, UN guiding principles, and so on. And when it comes to the question of the community, it becomes more complicated because the community has a position with regard to this global interest, and obviously I have to, the disclaimer of this is that when we speak about the community, we're actually speaking about, in this particular case, of over, as I said, 250,000 people. The way that they are structured is quite complex. This particular people is structured under family units. It's a decentralized way of governments, and so consulting with them and knowing who is the representative of these communities is a challenge. Not even the state knows necessarily, or doesn't have it necessarily mapped out. So this issue of internal self-determination and where it's going has a significant challenge in issues of representation, basically, for these communities. But generally speaking, and again, without going into many details of the facts on the ground, communities aren't necessarily grounding their claims on the global interest or the community interest on which the state and the investor are grounding their position. A critical approach to what climate change entails to them, and this opens the door to perspectives of critical legal studies, perhaps third world approaches to international law. The fact that the minerals, the wind, are located in their territories, and that we're discussing access to those territories. Does it evoke, yes or no, these patterns of colonization, exploitation, whatnot, and there's a tension there within the community, right? The issue of development, the issue of infrastructure, of benefits that the project can bring. On the other hand, this issue of not being fully represented within this process, of not being fully acknowledged in international law under this process. And I think in the case of Colombia particularly, because in general this kind of tension between communities and the state and natural resources, this tension is underlying many South American jurisdictions, but in the case of Colombia, I think it's really interesting to see and challenging to see how the depth of internal self-determination is deepening, in the sense that, and this is very recent, this was this past 6th of June, the government, together with associations of indigenous communities, have established the guidelines for the establishment of indigenous communities as environmental authorities within their territories. And so we still have to see how this decree is going to play out. There is an outline of the decree. It's interesting that in the decree, the general interest is characterized as the protection of ethnic diversity and the conservation of the restoration, preservation of the environment, based on a principle of maximization of autonomy of the indigenous peoples. And so this is the progressive principle that would feed the development of this new capacity that they would have or will have under Colombian administrative law. So if that is the case, and this self-determination is to the point that they are also the environmental authorities in their territories, does it say something in terms of how far a state declaration can generate a reasonable expectation, for example, for an investor, if in fact this is an autonomous organ of the state? I think there are issues there of state responsibility that are interesting to uncover as this develops forward. And so we have these three different positions, and they all have in common this interest, critical, positive, on surrounding the issue or the global interest, the common, the community interest of climate change. But as we see it, we have different subjectivities that aren't necessarily acknowledged in international law, or that are acknowledged in different degrees. Obviously, we have the state, we have the investor or the corporation that is sort of this hybrid position, and then we have indigenous communities that, in my view, with this trend towards a stronger internal self-determination, perhaps, are also themselves, just like the state, starting to pop their head a little bit beyond state territoriality. I don't know. It's just something that I'm, thinking and I'm saying out loud. And these different actors and their different qualities under international law also translate into different instruments of international law that don't have the same quality. And so, you have your traditional binding frameworks, and you have your soft frameworks, these MOUs to cooperate for renewables. You have the business and human rights frameworks, and you'd wonder how these different frameworks and how these different personalities and the development of their positions within in this case the energy transition can effectively or could be read harmoniously. How is an investment tribunal to interpret? Again, as I mentioned, the expectations that an investment can develop based on essentially what is a fractured territoriality. It's obvious that despite the state having a duty to consult, the indigenous communities are gaining more and more ground in terms of what they can or cannot, or in terms of what they can do, basically, with these projects. And I think it's interesting to note that so 2023 was this turmoil of the prior consultations in the Wahida. They had to do over 200 consultations because it's a huge territory and it's full of settlements, and with each settlement, they had to consult. And so a big effort, and at the end of this, and along the way, Enel just stopped, station, got off of this train. Along this way, this is also, and right after, shortly after Enel's decision to halt, there was this pact that was signed for the just energy transition in La Guajira. And in this pact, it's interesting to see that it's convened by government, but if you see who's signing, it's not just the national government that signed the pact. Apart from companies that are signing, you have ethnic authorities, you have territorial entities, and then you also have international cooperation. And the signatories, perhaps, of this pact, which is also understood not to be binding, it's very clear. They stated expressly, it's not a contract, it doesn't generate any kind of obligations, but it's our road path, basically, to generate a just energy transition in the region. And so it seems sort of to reflect those sentiments of how these different actors need some kind of framework to be able to interact together. Certainly, it seems that international law isn't really catering to those different actors and their interests and their representativity, the current arrangements. And so there's some questions that raise for international law. Many of them I've already alluded to, and I was telling Christina previously that this is just some thoughts that I've had in my mind for some months now, as you see these events evolve, and you wonder, what does this mean for the responsibility of the Colombian state? What does this mean for indigenous communities? And to me, it seems that there's an interesting question, which I already alluded to, with regard to self-determination, the way that it's deepening in Colombia, and whether this can effectively change or should change state responsibility. I know it's, I don't know, maybe it does. It's just a very too much of a bold statement to make, but to the extent that the state can't really represent the final decisions that the communities will take, are these decisions that the community is taking part of, to be understood as decisions that belong to state organs, or should we, think of perhaps some other kind of subjectivity for indigenous communities? This could perhaps be, it's just one idea for research. The other has to do with participation. So I mentioned at the beginning that the state is pursuing these soft agreements, these MOUs for cooperation, and these are interstate agreements, and so they're firmly planted in this notion of international law as being an interstate regime. Do states have the obligation, basically, even within these agreements that don't generate international obligations, or precisely because of that, because it's an instrument that is flexible and allows participation of other actors, should communities be part of those agreements in terms of what are the cooperation and the agreement and the commitments that entail from there, perhaps also as a way of risk management from the perspective of the state. You have the community on board when you negotiate or when you sign these MOUs. From the point of view of the corporation, it seems also interesting. The corporation is interacting with perhaps an emerging subjectivity under international law, is Does this mean that also the corporation, when it enters into these mutual benefit agreements, are these quasi-state-like mutual benefit agreements? Is there something there to say of, how the corporation is engaging perhaps with a quasi-sovereign? This is a claim that the indigenous communities have, of perhaps a new sovereignty that is, yes, it's territorially anchored within a nation state, but it's also delimited within that nation state, and it increasingly has more state-like competencies, at least it seems so far in the Colombian scenario. And in the case of the communities, are they, with this development, are they perhaps going beyond, or is this internal self-determination, even if it's not affecting nation-state border boundaries, to the extent that it is taking on more and more, prerogatives of state power? Does this change the notion of internal self-determination? Does this mean that there's an emerging subjectivity for these communities under international law? Can we explore a different notion of subjectivity for these communities? Do they themselves, to the extent that they would participate perhaps, in MOUs or express or generate expectations for investors, do they have an international responsibility in face of the investors? Because obviously there's a question here of governance of the communities, of representation of the communities. In the case of this particular community, it is very fractured. I was telling you, it's a decentralized governance structure. And even the representatives that the state has mapped out, so the government has mapped out, don't necessarily reflect the ancestral authority that resides within the community. And so as the community undertakes more and more competencies, should it rethink the way its government system aligns with these kind of competencies? Do they have themselves obligations under climate change? The fact of them halting the projects, or the dysfunction of their internal decision-making processes, does this generate for them some sort of liability, or that translates to them directly and not to the state with regard to climate change? So, yeah, I mean, more than really putting forward conclusions on these questions, the point was sort of to take these developments that are very recent, very fresh, past year in Colombia, very complex, far from being solved. And it's just an example of how, with the energy transition and the rush towards minerals and the generation of renewables, so we use the example of the wind farms, but there's an issue of access to critical and strategic minerals, obviously, and with a country that is full of indigenous territorialities, particularly, I was showing you in this map, an unexplored country, but the Pacific Rim for copper, for example, you see it's all fully dotted with indigenous communities. It is foreseeable that this will represent, a new avenue perhaps for research and challenges in international law, as these subjectivities that were usually, within the purview of the state, in fact, impact and can have a say on whether these energy transition projects have a way forward. Thank you.
Okay, do we have questions? Yes, Miriam.
Thank you for your very insightful presentation. I was wondering concerning the cooperation agreements, if there is already a mention of the indigenous communities and of their interests to protect them, or if the effect of protecting these indigenous communities would solely lie on including them in the cooperation process of the agreement.
The cooperation agreements, the ones that I've seen, don't mention the communities at all. Mm-hmm. So it's just an interstate. It's an interstate arrangement. It doesn't say anything at all. The point that I was making is that one approach is to say that the mere fact that the state is intervening in the arrangement implies the protection of the communities because the state has a duty to consult the communities and so on. It has obligations with the communities. But in this different kind of reading and with this different kind of subjectivity, you'd wonder whether the communities as such should be there in the negotiation of the MOU. or on the spin in the negotiation on the spin-offs of the MOU. But that hasn't happened, and that's one of the points that I'm perhaps raising, is that they, under renewed and reinforced also mandates for participation. So Colombia is in the process of ratifying the Escobar agreement, which has these, just like the IRIS agreement in the European context, these enhanced duties for states, obligations for states to deepen participation. Should these communities participate in these scenarios? It's challenging, again, as I said, because when we speak of communities in Colombia, we're speaking of very different peoples and with very different governance systems, and within the peoples, there can be a lot of fractures, and so there is an issue of representation, who is representing the communities in these MOUs. But that could also be, something that could be further research on the subsidiarity principles, for example.
So my question was, so if I understood correctly, the government itself owns the subsurface, and the indigenous communities own the surface. Is that a typical arrangement? Does that comply with the rights of indigenous peoples as understood by the UN declarations?
It's very typical. I mean, if you look at the history of mineral tenancy in Latin America, there were fluctuations where the owner of the soil would also own the subsoil. But right now, the regimes, in generally speaking, in Latin America, and also in some states, as far as I understand, in North America, have this kind of split tenancy, because the natural resources under the ground are seen as serving a public interest that transcends the territorial ownership of the communities, and should serve the broader community that is under the statehood label.
And are there not arguments to say that, as I understand it, that indigenous communities have a right to the land and the resources to which they have traditionally been coupled with? Does that not include the minerals beneath the earth?
Yes, there are arguments in that regard. I mean, the fact that they, for example, are to become an environmental authority, which is in progress, and we still don't know, what the scope of this would be, and it wouldn't be detached from, environmental licensing at the central level, perhaps speaks to that. Speaks to what they would authorize and how they would authorize it. But fundamentally, the regime, and it's artificial, obviously, it's complex, decouples both of these things. The challenges come because effectively to access the subsurface, you need to go through the surface, and you need to speak with the people that are living on it. And so yes, there are a lot of arguments, and among the indigenous communities as such, there's also this movement towards gaining a full ownership of title, including the subsoil. The Canadians have some of their territories are like that. They are also subsoil owners. But in Colombia, this is a constitutional provision, and so this would, for example, require a constitutional amendment if you were to change that. The issue, the prior consultation or the mutual benefit agreements should work in that direction, should work in terms of coupling these competing interests between a broader collectivity and a community that has a de facto access to subsoil.
Yes, thank you for this interesting presentation. Just a couple of things. I'm not sure if this issue, existing regions can cover some of the issues you raised. We have different regions that touch upon, I think, some of the issues you raise here from a different perspective, maybe, such as for example, at the international level, we have the Convention on Biological Diversity, which requires prior informed agreement, consent of local communities, of course, from environmental protection perspective and access to genetic resources within their land. they should have their prior informed consent. I think that's a very clear obligation, and benefit sharing is already there in that context. And then even at the Andean community level, you have Decision 391, which clearly requires that access to resources such as genetic resources and so on, and indigenous people's land requires their engagement, involvement. Actually, prior informed consent should be given. I know that this is not really exactly about genetic resources, it's about minerals and other raw materials, but I'm not sure if that can still be somehow relevant in this regard, existing systems. Even at the national level, as you know, we have environmental impact assessment procedures where communities should be involved, and their participation should be secured. So I'm not sure if that could be explored in this way to cover some aspects of the problems you raised here. And my second point would be on the issue of investor obligation. I think that's also critical. In a new investment protocol we have in Africa, the African Continental Free Trade Area, we have now like a treaty, a protocol on investment. We have included a chapter on investor obligation. So some of the issues they are already part of that protocol. Local communities, indigenous people. By the way, the word indigenous people is not accepted in Africa. We call it local communities, but in Colombia, in Latin America, we know the story. Even in your presentation, I see that you used both local communities and indigenous people. Each continent may have its own history and so on and so forth, but nobody is interested in indigenous people. Everybody's indigenous in Africa. So it's like local communities. Anyway, it may cover either way. So we have obligation to consult local communities in that case, every investor, before making that investment. And the state is under obligation to make sure that the communities are engaged, they participate in decision making and so on and so forth. I'm not sure if such obligations exist somewhere like in Colombia, or I don't know, and that could also help in this regard to ensure that at least some of the concerns you raised could be considered from that perspective also.
Yeah, so on your note about indigenous and in Colombia, it's tricky because not all Colombians are indigenous in a strict sense. And so we do use indigenous communities, and when we speak of local communities, it may refer to, and this is something also very curious about the legal framework in Colombia, communities that live on the Pacific Rim that are of African descent. They have a regime that has collective title to land, so similar in many respects to the indigenous communities' collective title holding and mining prerogatives and all of that. And then you have the local communities that are the local farmer communities that are also sort of organized, and there's also questions on whether these farmer communities are in themselves a subjectivity. So that's a bit, it's a bit layered in the Colombian context. Regarding participation and benefit participation, yes, and it's also, for example, it's included in C-169. The convention refers to the communities participating in the benefits of the projects. I think there's a fine line, and the question is, between a meaningful participation, consultation, consent, and these instruments are sort of treading it, and so the C-169 refers to a meaningful participation whose objective is a consensus but not consent, and in that regard it differs from FPIC. But that is a line that's moving. I mean, in terms of the Colombian constitutional framework, and in terms of how things are actually playing out on the ground, it's quite obvious that if you don't have the buy-in of the communities, you won't have a project. And so I don't know if so the participation mechanisms are strong in Colombian law. Usually in these countries, the issue is implementation. But if you look at participation, there are several instances of participation: environmental licensing, in mining licensing. There's a protocol for participation, and then there's prior consultation when a project reaches the exploitation phase, although increasingly also the exploration phase. I think savvy business, savvy investors know that ultimately they need consent, and that I think is also shifting this line, because the kind of arrangements that they're entering into are arrangements that, yes, you need to rely on the state because the state has the obligation to consult. The company cannot do that. In some states, in Latin America, for example, in Peru, it's prohibited for the company to make first approaches without the state doing them first. In Colombia, it's different. In Colombia, the companies can start, socializing, we say, a project with communities before the state carries out the prior consultation procedure. But the corporations are understanding that the state alone isn't making the trick. That they need to engage directly with the communities under different kinds of arrangements. And that's where I wonder how these international arrangements, which you refer to, but also C-169 is an interstate agreement. It refers to benefit sharing. Does this mean, or could it be interpreted to the extent that corporations, for example, have an obligation then to enter into a mutual benefit agreement with these communities, and how is benefit sharing looked at, right? Because some states would say, yes, we pursue benefit sharing through payment of royalties, and we as a state administer this and benefit the communities. That's one view, and it's very state-centric. And the problems are solved because it is understood that the communities are part of statehood. But what we're seeing is maybe that's not necessarily the case in Colombia, at least, where this internal self-determination is so strong.
Other questions? Otherwise, I have a question. I was wondering, with regard to the law that you showed, the very progressive one from the 2nd of June, I think it was.
Oh, yeah.
Yes, it said basically, if I recall correctly, that the indigenous communities become part of state authority, right? Because they basically do something for the state. Doesn't that go with an inherent risk for the state? Because whereas before they were independent and the state wouldn't have responsibility, now they're acting as a local or government authority, and now actions that they do may actually, the state actually may be responsible for with regard to public international law, and especially, of course, the BITs. So, well, on the one hand, I think it's an interesting idea to have them as a state authority, or like part of it. Doesn't it also increase the risk?
Yes, I mean, I think it increases a lot of scenarios of risk. To begin with, because the communities, despite having this deep internal self-determination, their governance and government structures are very feeble. And so they already undertake a lot of state competencies. For example, in Colombia, they have their autonomous jurisdiction, which is applicable only, though, to members of the community or to facts that happen within community territory. So there's some rules sort of jurisdiction of how their law would apply in a specific case. And this has raised questions, and I'll just mention it, it's not my area of expertise, but from a human rights perspective, on corporal punishments, for example, is the state then liable, for example, for corporal punishments that occur under this kind of jurisdiction? And there's some interesting constitutional jurisprudence on how to sort of couple this multiculturalism with state obligations internationally. And yeah, I think in the case of environmental law, although we still have to see, what the extent of this will mean. Will they be licensing projects? Are they really to be understood as a state organ when they do this, or is this an expression of this internal self-determination that is sort of decoupling them to a certain extent from the state? That surely isn't what the state wants. In fact, the state refers to later on in this draft decree to principles of concurrence and you know, they should be aligned basically with state authorities, but you know, principle of maximization of autonomy of indigenous peoples, where can that lead us? I think that is something that Colombians still have to see where it will lead, and it raises these questions of state responsibility, which you're rightly pointing out.
Yes, regarding that, if you say those administrative structures are quite feeble, how do I reliably integrate them into a strict legal framework? Because what you described is decoupled, right? And if it differs from community to community, do I have to find out anew every time I need an environmental permit? Or like, I can't imagine.
Yeah,
Basically, that's my
it
question.
can be very messy.
Okay.
Again, I don't know how this will play out, but for example, with prior consultations, it really depends on how is the governance structure of that particular people. If it's centralized and they have a council of elders and so on, and you know exactly who's taking the decisions, that's easy. The problem is bringing together these different forms of decision making with a decision making, I suppose a Western form of decision making that requires a legal representative of the entities to sign off a deal. And that's where it becomes fuzzy, because yes, the government will map out the legal representatives, but within the communities, the source of authority won't necessarily reside within the legal representative. And so the engagement with the community requires going beyond the legal representative. It requires really, you know, knowing who you're speaking to on the ground and making sure that the buy-in for that decision comes from the adequate source of authority, because otherwise it wouldn't be legitimate, even if it's signed by the legal representative that is mapped out by the state. I suppose in the case of, but this is something that will evolve in the next weeks. How would it work outside of a context of prior consultation? We'd have to see how they will manage it. If there will be a centralized, you know, desk that would be taking care of this on a national level or regional or by peoples and so on. It's a room for experimentation, I suppose.
Any more questions? No? Okay, I think we're also basically on time. Then thank you very much for your presentation. I think we all took something away from it, and we all maybe started with more questions than answers, but definitely very thought-provoking. Thank you, Lina, and I hope we see you again sometime, maybe in the future or after lunch when you come around to Germany and have a